Recording.
Good afternoon, everyone. Thank you for joining us today. My name is Claire Brilio. I'm the Communications and Business Disruption Resource Director for the Economic Development Collaborative, and we have an exciting webinar today for you. I just want to say thank you for everyone who has been showing up on Wednesdays. We've had so many people register for this webinar. We've had over 360 people registered. So I'm just going to give a little bit of time as people come in. You will notice that your video is off and you are muted, but there will be time for Q&A at the end. So I'm just going to pause for a moment as people come in. Give us one second. Okay, we'll get started here. Today, I am joined by David Alvarez, who is a partner and attorney at Alpert Barr and Grant. He has over 20 years of experience in tenant law, and he is going to be giving us a short presentation today and then answering as many questions as he can. I know there are so many questions around this issue with tenant rights and landlord rights and commercial leases and what to do when. And I just want to acknowledge this moment. We've been connecting with over probably 6,000 individual businesses within Santa Barbara and Ventura County. And this has been such a hot topic of question. What do I do? I don't have enough money to pay my rent. I want to renegotiate with my commercial landlord. What recourse do I have if I want to get out of a lease? And so for that reason, we reached out to David, and he graciously agreed to be on this webinar today. And we're very happy he is, because I'll just be honest, I'm not the expert. So I'm going to give my screen over to David in a moment, but you'll notice that you're all muted. Your screen, you're not able to share video. We'll have a time for questions and answers at the end. I am joined on the back end with Brianne and Emily from Visionality, and we're so grateful to them specifically. They're the queen of webinars, all things webinars. So if you need help with webinars, feel free to reach out to Emily at Visionality. And you will notice at the bottom of your screen, you have a chat feature and you have a Q&A feature. And we will be answering questions at the end. So I would invite you to hold on your questions until the very end, because David most likely may answer one of your questions during his presentation. And the chat feature is to be used if you have technical issues. So please do not enter your questions in the chat feature. Please enter them in the Q&A, and David will go through them at the end. Emily will be assisting them as well. And we have about an hour and a half today. There will be a recording going out with this webinar, and a worksheet as well, not necessarily the PowerPoint, but an updated a worksheet that gives you a lot of the information that David will be covering. So stay tuned for that. And with all that, unless there's anything that I need to know, nope, I'm going to give it over to David. Brianne, thank you.
Thank you, Claire, and thank you for the opportunity to speak to everyone today. Again, my name is David Alvarez. I am a real estate attorney, litigation attorney, and a business litigation attorney. A large part of my practice has been representing landlords and tenants in commercial disputes. I do also do residential, but my really expertise is in commercial leasing. So I'm really excited to talk to you, because this is really a hot topic, and I'm getting a lot of calls from my clients or other people asking what to do when their business has really been affected by COVID-19. I also want to let all of you know that in addition to being a lawyer, I'm a small business owner who's been incredibly affected by COVID-19. I actually own a craft beer bar in Hollywood, right next to the Pantages Theater and the Fonda Theater, and we've been devastated. So like all of you, I'm out there applying for PPP loans, applying for EIDL loans. I've been working myself on the weekends to just keep the doors open. So I come from that perspective as well, that I understand what you guys are going through and how hard it is, and how revenue has just dropped significantly. And how do you navigate? How do you pay rent? How do you talk to your landlord? Landlords also have the same problem. They have more loans to pay. A lot of them do, and they're trying to figure out how to move forward. So I come from both perspectives, and again, wanted to let you guys know that. I also grew up in the city of Ventura, so my family's there, and so it's my home. And so anyway, but all that, let's get started. So, the first thing I wanted to discuss with everyone is, in any negotiation you're going to have with your landlord or moving forward, the state, the counties, and the cities have initiated some temporary regulations, and we'll get to that in a little bit. But most importantly, your lease is what's going to control as to how you negotiate with the landlord, how you move forward, what the actual, what your rights are. So I'm going to actually put up a little PowerPoint that, let's see if this works. Can you see the PowerPoint?
We can see it.
Great. So moving to the next page, the lease controls. So I want everyone to understand that presently 99% of the leases that you have with a landlord has a paragraph in there that says, if you turn your keys into the landlord, that's a breach of the lease. So that entitles the landlord then to file a breach of lease action against you and recover damages. And I'll get to those damages in a second. So, you may have talked to people and you may have heard that, hey, I can just walk away and give the landlord my keys and, nothing will happen after that. That's not necessarily true. And in fact, it's going to be a breach and open yourself up to potential liability, both your business, and if you've guaranteed the lease, you're going to be liable personally, and your assets, your personal assets, could be at risk. Most leases didn't contemplate the COVID-19 pandemic. So when you talk about issues of abatement of rent, they only usually apply to destruction to the premises. So whether there's hazardous substances, whether there is fire, whether somebody drives a car through your front window, that is when you have discussions of when a tenant can be relieved of either having to pay rent or maybe even being able to terminate the lease. And as you can see from the PowerPoint, I have section 13 of AIR. That's the AIR lease. That is the general lease that most landlords use, unless the landlord has their own specific lease. Most of you probably have an AIR lease, either an office or a retail AIR lease. Not everyone does. So it's just, that's what that AIR refers to. And then, other issues is, do you have business interruption insurance? Most leases require you to have it. What type of business interruption insurance do you have? I hope everyone who has it has made a claim to their business interruption insurance. Most likely it'll be denied, but you should do so. I don't know, and we'll get to this in the question and answer period, but how many of you had lawyers review your lease before you signed them as a tenant? I can tell you the landlord had somebody review it, and if you don't already know this, the AIR lease and any landlord lease is 100% pro-landlord friendly. And you should always, try to budget in your, startup costs, having a lawyer review your lease. I can't tell you guys how many times I see somebody come to me and, have a question about, a lease, like the way a lease is written, a landlord can delay opening up 6 months and the tenant may not have any recourse. Delivering the space to the tenant. And if the tenant comes to me and I say, well, read the lease, it says they have the right to do so. Things that lawyers who practice real estate law, they can try to cap increases in your triple net charges and, could put in a force majeure clause. In fact, in the future, you're going to see this most likely, where a pandemic will give you the right to get out of your lease. So everyone needs to look at their lease and start looking at what their rights are, because it's going to control how we navigate these waters moving forward.
Hey, David,
Yes.
do me a favor and click that little presentation button down on the bottom right, and it'll make it a little bigger.
Oh, there you go.
Thank you so much.
I thought I had done that, so thank you. I appreciate that. So one of the things I wanted to mention is in calls that I've received from potential clients is, my business is destroyed and I need to get out of my lease. I need to get out of my lease. And I don't see my business getting better in a year, 2 years. I need to get out. Well, as I said before, abandonment is a breach of the lease. And if you do that, you're going to have to prove as a tenant that you had an excuse or a legal right to break the lease and not have to perform. So some of the defenses out there are commercial frustration, impossibility or impracticability, force majeure. If you have that in your lease, which the version of the AR lease that I have doesn't even have it. And force majeure is act of God. An act of God has prevented you from performing under your lease. And the Civil Code has this section 1511 that talks about excusing your performance if there's some irresistible, superhuman cause or an act of a public enemy to the state or the United States, unless the parties have agreed otherwise. So these are the defenses that you may have if you turn over the keys. This is what a tenant will argue why they were relieved of their obligations to pay rent moving forward. I started looking at some case law because I had some tenant come to me that said somebody had told them, you can just get out of the lease and you're going to be excused. And, I was trying to think of situations that are similar to the situation we're in now. And, you could imagine when prohibition was passed by Congress, people who had bars, I'm sure they were adversely affected by the change in the law. World War II caused a change in production. And I came across a case, it's called Lloyd versus Murphy. And it's a shop in Beverly Hills where 90% of the tenants' sales were new cars. Another 10% was selling gasoline. And the government issued a law that because of the scarcity of resources, nobody could sell new cars anymore. And this was in 1941. So this tenant said, my business has been destroyed, and he hands over the keys. And if you read the case, the court goes through a full discussion about impossibility, commercial frustration, and held for the landlord and said, government regulations that may, unless it totally destroys your business, we're not going to get in the middle of that. And there was some language in here, and I'd be happy to share with you. If you want to give me a call, I could talk to you more about the case, but that's like right on point today. So I'm not saying you shouldn't, and we'll get into this, come on to the question and answer, that you shouldn't. Handing over the keys is a strategy. that you may end up employing, because the alternative is I can't keep my business open. But I wanted just you guys to understand that there are consequences, and I don't have a right answer one way or the other now as to how a court is going to decide whether tenants are going to be excused. And so, one of the things I want to make sure all of you do understand is there's no silver bullet. There's no right answer on any of this stuff. It's all new. It's going to be the interpretation of, laws that took place or cases that took place in World War II or during Prohibition. And we all don't know what's going to happen. One of the arguments that's going to, I think, work against tenants is all of the actions taken by governments to keep businesses open. And as all of you, I can attest, we feel like they haven't done enough. But the idea of getting a PPP loan or an EIDL loan can keep your business open for a period of time. Or as I get to the eviction moratoriums, it has relieved your obligation to pay rent, at least presently. So I can foresee a landlord making an argument that's going to say, well, their business wasn't completely destroyed because they got money that allowed them to weather the storm. And it's also going to depend on what kind of business you have. If you're a movie theater, if you're a bar, well, your argument's going to be a lot stronger than somebody who just has a retail business that is still open, or a restaurant that's able to offer takeout. So these are all issues that we don't know how it's going to play out. And in my practice, I use these terms to try to negotiate some sort of resolution with the landlord. So I use these terms because you're going to want to, when we talk to your landlord, and you get to a place where you have no other choice either to try to get an agreement with the landlord that's going to either reduce your rent significantly, defer your rent significantly, you're going to want to kind of use these keywords to say, well, look, if I can't keep going forward, I'm just going to get out of the lease. You're going to sue me, and I have a ton of defenses that I think a jury or a court is going to be, they're going to have sympathy for me and may rule for me. And so now is the time for you to make a deal with me, because if you make the deal later, it's going to turn out to be bad for you. So that's just something for you to know about. So let's go to the next slide. As I told you, you guys have all opened up your business and you're taking your chance, and you're living the American dream and trying to put food on your family's table. As I said, if you end up walking away, the damages a landlord can recover against a tenant are all controlled by Civil Code Section 1951.2. And what 1951.2 says, and it has to be in your lease, but I can guarantee 99% of all leases have this provision. The rent that has not been paid becomes due and owing in a breach of lease action. But in addition, all your future rent, so if you have a 10-year lease and there's 5 years left on that lease, those 5 years become due and owing right then. And the code section has a formula where you discount those damages to present value. But you're looking at, if you owe $2 million in rent over the next 10 years, those $2 million are going to be due, discounted to present value. They're going to be due as soon as the landlord gets a judgment against you. In addition, the landlord gets all damages necessary to compensate them for the breach. That includes real estate broker fees, tenant improvements, and that's if they gave you a tenant improvement allowance, that's recovering those tenant improvement allowances and paying for the tenant improvements for a new tenant to come in and replace you. Those are usually prorated, but a landlord can recover them. There's case law out there that says landlords can even get capital expenditures. You know, they have a certain building that is housed a certain tenant, say a movie theater, and now they have, you know, there's no movie theater that's willing to come in. They have to repurpose it for something else. You could be on the hook for that difference. And of course, attorney's fees. Now, when you do breach the lease and hand over the keys, the duty to mitigate turns over to the landlord. And this is, I think, a really important point for tenants to understand is, and this is why handing over the keys may be a strategy you employ, because by handing the keys to the landlord, now it's on the landlord to go find a new tenant to replace you. They have a duty to do so, and they have a duty to use their best efforts to do so. And if they don't, you can be relieved of your obligation to pay rent. It also delays them collecting from you. You know, right now the courts are a mess. There are no evictions taking place, and I'll get into that in more detail further in the presentation. And all trials are being continued, and I can tell you, I'm having trials that were set for, you know, September and October being moved till July and August of next year, and I think that's ambitious. I think that trials are not going to start till summer, earliest September of next year, because you got to get through all the trials that are already set. So if you file a new lawsuit, you're looking at 18 months to 2 years before a landlord gets into court to try to collect rent that he may be owed by the tenant. And that may allow a tenant to regroup, to reassess. And that's an argument to be made to the landlord is, hey, if I leave, no one's going to replace me. You're not going to get any rent for the next 2 years. Yeah, you may get a big judgment from me then, but good luck collecting. And wouldn't you rather sit down with me and have a discussion and really talk about how I can stay in a way that makes sense for both of us? So when I'm dealing with landlords, I'm making these arguments to their attorneys or the landlord that, you know, my client hands over the keys, good luck, because you're not going to find someone to replace them. And we're willing to work with you at this point and sit down with us. So that kind of takes me to the next slide, which is what I'm doing a lot of now is trying to negotiate new sort of rent agreements. I'll call them rent agreements, you know, new agreements, new amendments with landlords and tenants that make sense for both parties to keep them in business. I'll get to the moratoriums. You know, right now, tenants don't have obligations to pay rent if they qualify under state, county, and city moratoriums. But as you may or may not know, none of those moratoriums relieve the tenant of the obligation to pay rent. And so that means the rent has to be paid back at some point. And so the landlord, at least all these state, county moratoriums, they say that the landlord's going to get paid back in full. And that sounds great for a landlord. But this is what I tell landlords, and this is what you guys should be thinking too, and I think you guys understand all this, is that for the last 4 months, at least the way these moratoriums are listed, a landlord's going to get their money unless they work with the tenant. They're going to get deferred. It's going to get worked out. A tenant is never going to get back the revenue they've lost. They are not going to, you know, the profits they lost, the revenue. So when you ask a tenant to defer rent till 2021, how does a tenant do that when, you know, their rent is say $10,000 a month and then it's going to jump to 15, 17, whatever the number may be, because they're not only paying the rent that's due that month, but now they're paying the other deferred rent over a period of time. And that's scary. That doesn't seem realistic. And it's really not doable. And I hope, at least my clients, my landlord clients, they get it. They understand it. And I think they are willing to work with tenants in a way that makes sense. And so some factors that both landlord and tenants need to consider as you try to negotiate a deal moving forward is, first of all, you got to assess what your relationship is with your landlord. Hopefully it's a good one. Look, not all landlords are nice, and not all tenants are nice. I actually represent a landlord who I believe are really nice, and they have 2 tenants at 2 different centers, and one works with the landlord, has been cooperative. The other finds a way to fight with my client any step along the way. Well, as you can imagine, with what's going on in COVID, the one that is cooperated with my client and has a good working relationship, my client is finding ways to work together so that both parties survive. The other one, my client's saying, I'm just going to follow the law. I'm going to follow the moratoriums in LA, and when it's done, you're going to have an obligation to pay back the rent. And it's unfortunate because, both parties need to figure out a way to work together. So when I get to, when I approach these situations with, I'm just going to, for example, a landlord, because I'm representing the tenant right now, put my tenant hat on. The first question I ask my tenant client is, do you have a personal guarantee? And a personal guarantee is a lot of the ballgame, because if you have no personal guarantee, you can tell the landlord, look, if I walk away, if you don't work with me, you're going to get a judgment against an entity that in 2 years or a year is going to have nothing, and you can't come after me personally. If you have the personal guarantee, well, that's unfortunate, because in addition to suing your company, they're going to sue you individually. And when they get that judgment, they're going to be able to collect on your bank accounts, your home, any other assets, your car, anything you own, they can seize. And that's incredibly, that's scary. It's horrible. That's why personal guarantees landlords make you sign them to ensure that they have a way to collect their rent if you can't pay. Another factor is how much time is left on the lease. If you have 10 years left, trying to get out of a lease is really difficult. It's hard. It becomes because the landlord's thinking, well, I got you on the hook for 10 more years and I'm just going to let you walk away. But it also, the good thing about a long term is it allows you potentially to figure out a formula to pay back the rent that you haven't paid during this period over a longer period of time. And so it goes both ways. If you have a small period left, a landlord may allow you to go, or the damages may be so low that you may risk saying, I'm just going to walk away. Can the tenant be replaced? What I mean by that is the type of business. If you have a restaurant and you can't, you're not making it and the landlord's not working with you, how does the landlord, when you leave, how does the landlord think he's going to replace you? Who's going to open up a restaurant in a space that couldn't make it during COVID? So, a landlord has to think about it from the perspective of, if I lose my tenant, when am I going to find a paying tenant to replace the tenant, I'm sorry, to replace the existing tenant. And that is, landlords need to start doing that analysis, because no one wants empty spaces. Empty spaces doesn't help anybody. You're not getting paid, and good luck finding someone to come in and enter into a new lease. The type of business that the tenant has, it kind of goes back to, a movie theater, a hair salon, a restaurant, an entertainment, a theater, a bar. If the landlord wants that tenant to stay, if he just thinks that landlord, he or she believes that, or it believes that entering into a deal that just calls for deferral of the rent, there's no way they're going to make it. And I think they have to start thinking about creative ways to keep that that tenant viable, including, abating rent. And abating rent means to forgive rent during this period. And so when these types of businesses get to open up again, they're not, they don't have the full impact of the rent and every other expense bearing down on them as they try to open up and try moving forward. I mean, if you've gotten PPP loans, only 25% of it could be paid towards rent and all your other utilities. The other 75% had to go to salaries. And I think it may have gotten lowered for certain industries, and I know it was extended. But the fact of the matter is, if you were like me in my business, I can't use that 25% to pay rent, because I need to use it to pay vendors that are providing me, my food or my beer right now. And because I have the protections of the state, cities, and counties, I'm going to delay that as long as possible. And that can be used to your benefit in these negotiations with landlords. The other thing that I have been using as a tactic to try to work out deals, whether they be, like I said, new rent agreements, lease terminations, or amendments to leases, is the threat of bankruptcy. So, a Chapter 7 is just a liquidation. You leave, and the business ceases to exist, and the landlord basically usually gets nothing and takes the space over after a period of time. And so you threaten a Chapter 7 and you tell the landlord, you're not getting anything. If you drag me into Chapter 7, you won't get a dime and you'll have no recourse against me. A Chapter 11 is what's called a bankruptcy reorganization. And that allows a tenant to reorganize their debt and figure out a way to pay it over a longer period of time, and it can reduce your debt. And under Chapter 11, you have the opportunity to reject a lease. And if you reject a lease, I think the most you'll have to pay on that lease is 1 year. So that is, those are factors to employ as you're talking to landlords, is you're going to put me into bankruptcy. And if you put me into bankruptcy, you're going to get very little at the end of the day. And I don't want to go into bankruptcy. I want to keep my business alive. This was my dream. This is what I've worked so hard to keep going. And I just need a little help. So I employ all these different tactics. And so to the landlords that are listening, consider these things from the tenant's perspective. Figure out a way to work with them. Figure out a plan. Realize that if you're a restaurant or a bar, your revenues are down 80, 90%. So, see what the tenant can pay and figure out a way to push it out later. Hopefully try to forgive it some of the rent, if you can. And these are the way you start the negotiations. The way I like to start a negotiation, and everyone has their different strategies, is I try to engage with the landlord from a perspective of, look, I'm hurting, my client's hurting, They'd love to stay. This is killing them. What can we do? And kind of explain what's going on and give some detail, especially if it's a landlord that you have a good relationship with. You know, be honest. You know, don't really hide the ball and say, you know, this is where I'm at. How I found is then landlords want to engage, and they want to engage in the conversation to figure out what they can do. And some landlords are going to just say, sorry, pay the rent, that's what you're going to do. And in those situations, then of course I change the philosophy and start threatening the bankruptcies, we're going to hand you the keys, good luck, get out, and there's nothing you can do. And then it changes and usually when that happens, they go talk to their lawyer, and then the lawyer calls and we see if we can try to work something out. I had a case recently where the landlord made some incredible threats to my client. I got involved, told her to almost laugh about it because there's nothing you can do. That landlord got a lawyer, and now the lawyer and I are having really meaningful conversations as to how both parties are going to survive moving forward. And I think we're going to strike a deal that works for both of us, my client and the landlord. So I'm happy to answer all questions regarding this. Every lease is unique. Every situation is different. So generally, looking forward to hearing some of the questions and some of the situations you guys are dealing with. But I also want to let you guys know some of your rights that you have now with respect to what the governor has passed, what's called the Judicial Council of California passed, what the County of Ventura and Santa Barbara have passed, and some cities that I looked at. So one thing to realize is that cities and the county and the state, they're changing and adopting new measures daily. So it's been hard to keep up with, but it's, when I look at any particular case, I make sure I go look back at these ordinances again to make sure they're still in place so I can give the right advice to my client. So right now, this Governor Newsom's order, it puts a moratorium on evictions through September 30th, 2020. The state offers, so no evictions can move forward, at least right now. It just got extended till September 30th, 2020. The state offers no timeline in any of their ordinances for the payback of rent. So under the state's guideline, whenever these emergency orders expire, the rent will be due until we get further guidance from the state or the legislature as to a payback period, some sort of uniformity in payback period. There was some talk in the legislature about, abating rent, meaning forgiveness of rent for certain industries. And there's been talk in the legislature about being able to modify leases. I think that's been stalled. I don't think that's moving forward. But we'll see. I mean, we'll really see. I believe the legislature and the governor are going to have to figure out something to give counties and cities uniformity of how we move forward once this pandemic ends. And again, the state gave local communities the authority to suspend evictions, which most have done. So moving to the Judicial Council's response, this was the Supreme Court of California response to the governor's orders. I think the governor invited them to do so. And these rules are really what is guiding the courts right now. And you should know as tenants, these rules should give you a lot of relief. So if you're having people threaten you that they're going to kick you out, change the locks, do all these things, they can't. It's illegal. So right now in the state of California, if you get a notice to pay rent or quit, which is the way you start an eviction proceeding. By the way, most of those it's illegal to serve those right now as well. If you can't pay rent because of COVID, you can't get a notice to pay rent or quit. But right now, no summons for any unlawful detainer can be issued in the state of California unless it's necessary to protect public health and safety. That requires a landlord to go into court and get a special order allowing them to get a summons issued for an unlawful detainer complaint. What that means is that no landlord can serve a tenant with an eviction lawsuit. So until at least September, and that order is in place 90 days after the governor declares a state of emergency to be over. So all evictions, or 95% of the evictions in the state of California are on hold. That's whether it includes non-payment of rent for COVID or for any other reason for an unlawful detainer. You cannot get a summons issued. In addition, no court can enter a default or a default judgment against any tenant, meaning they can't, courts will just reject a request for entry of default or a default judgment against any defendant right now in an unlawful detainer proceeding. Normally, unlawful detainers are expedited proceedings. You have usually 5 court days to answer a complaint after you're served, and then the trial is supposed to be set within 20 days of the answer being filed. Well, that's been now extended to 60 days. So that gives more relief for tenants to figure out what they're going to do. And as I told you, the order will expire 90 days after the governor declares the state of emergency to be over. Now, I can tell you, everyone, in my experience, at least in LA County, and I believe this is in most, if not all counties, writs of possession, which is the document that a landlord delivers to the sheriff to execute a lockout, they're not being issued by any county courthouses. So, for example, this is the protections that tenants have now. I have unlawful detainer judgments that I obtained pre-COVID that because of timing and when they would expire, I worked out a stipulation where the tenant had some extra time to stay in the premises. The expiration happened during COVID. I can't do anything about it. Getting the tenant out. My client has a judgment. And when I try to get the writ of possession, the document that I need to take to the sheriff to initiate the eviction, the court say sorry, and they just reject it and send it back. And it's my understanding that, at least in the LA County, the sheriffs are not doing any evictions or any lockouts. And I think that's probably most, if not all, counties doing the same thing. So the Judicial Council rules, these are codified rules, protect tenants. Nobody can go in and get an order to have a sheriff that's going to come remove you from your premises right now. And in the commercial setting, protecting public health and safety, that's going to be a very hard standard for a landlord to get over in order to get that summons issued. I mean, you'd have to be doing something really illegal, or threatening people to something like that in order for that landlord to go in there and get that exception. It's not going to be because your rent's not being paid. So we also have county responses. And right now there's an eviction moratorium for the non-payment of rent in Ventura County. That order's been extended till September 30th. It's actually doesn't say that, because it actually says it expired on May 31st, 2020. But when you read the ordinance, it says that every right that the governor gives will be extended to the county as well. And so I had to read it 2 or 3 times to understand that and see that it is extended through September 30th. So a tenant must notify the landlord in writing within 30 days of rent being due that they cannot pay rent. Now, you'll see a lot of these moratoriums say that email and text is okay to do that. And I would advise you guys that that's probably okay. But remember, going back to your lease has a notice provision in the lease that says any notice under that lease or any sort of official act must be given to a certain address, and then the notice provision talks about how you give that notice. It's in writing. It's by usually mail, overnight mail, or personal delivery, sometimes email, if you have the email address of the landlord. And so I think the text email thing is really more for residential. And I'll tell you that if I'm a landlord, I'm going to make, if you just send an email or a text, you potentially are going to have the landlord make the defense that notice wasn't properly given, that you couldn't pay rent. So you may want to follow your notice provision. That's just an argument, but I'm just recommending that you follow the notice provision in your lease. It just takes away an argument from the landlord. And then each ordinance has what sort of detail that you need to give to that landlord in writing, and certainly can talk to you generally. And I think, I could be wrong, that in each one of these ordinances, they'll be made available for you to click on in this slideshow. And if not, you can just contact me and I can email it to you, and you'll see the writing of what you're required to do to establish that, you know, the relief from having to pay rent. Ventura County ordinance. Yes.
I'm going to go ahead and put your contact information in the chat, and it'll also be on the email that everyone receives. But what I'm hoping, it's 12:46. So what I'm wondering is, should we pop in and answer a couple of these questions to make sure we get to them?
You know what? Give me 2 more minutes and then we'll move on to the questions, because I'll just wrap up generally with the different, it's not going to take me long to go through these slides, and then we'll go from there.
Sounds good.
Okay. So and again, County of Ventura, no payback of rent timeline. So you don't have a deferral. You know, LA County gives you a timeline. City of LA says you have 6 months to pay back the rent. Santa Barbara County, the moratorium has been extended to September 30th. Tenant must give written notice of the failure to pay rent, and you have to demonstrate your inability to pay. And again, we could talk about that. You know, it can be, I'm very wary of giving someone a bank statement. You don't want to give a bank account where they can potentially collect on you later. A profit and loss statement may make sense. Detailing your sales. I mean, you know, it's a no-brainer that if you're in the type of retail industry that's dead, they're going to understand you can't pay rent. Santa Barbara County, no payback of rent timeline. So understand that in the counties, if cities have made an ordinance, the city ordinance is going to control. If you're in an unincorporated area of a county that doesn't have a city ordinance, or a city has not adopted an ordinance, then you're going to be able to rely on the county ordinance. City responses. Ventura, eviction moratorium. It's extended through September 30th. You must notify the landlord in writing within 30 days. Same thing, text or email. That says text or email. You have to demonstrate your inability to pay. Ventura has actually codified that the tenant will have 6 months to pay back the rent after the expiration of a local emergency. And a landlord can't have late fees. And I believe most of the ordinances do not allow for the payment of late fees. So Ventura, if you live in Ventura, you're in better shape than most. Oxnard, you know, eviction moratorium, 30 days, you have to give the landlord writing. No payback. So Oxnard, you don't get the 6 month cushion, right? At least right now. Camarillo, same thing. Eviction moratorium. You must be able to demonstrate your inability to pay. You have to give the landlord notice in writing of your inability to pay, and no payback timeline. And City of Moore Park, they give 6 months to pay back the rent. The eviction moratorium, notify the landlord 30 days, must demonstrate an inability to pay. Finally, City of Santa Barbara, an eviction moratorium, you have to notify the landlord within 20 days. And by the way, if you haven't notified the landlord before, just do it now. I can't imagine that a court is going to punish someone if they may have not done it in months past. Do it now. So I think you'll be okay. You know, at least that's my thought. Must demonstrate your inability to pay. Now, I read the Santa Barbara ordinance that there is no timeline to pay back rent, but it actually talks about deferred rent, and it really has language in there talking about the parties working out a fair timeline to pay back the rent. I have a well-respected law firm that I know who in their chart says 1 year. I don't see 1 year, but it's just something to think about. And I'll try to get clarification on City of Santa Barbara on that issue. So here's my contact information. You'll get it. Other cities may have, in the counties, have other ordinances. I focused on these. Usually you can just go to the city's website and they'll have it there. And that's all I have. You guys have any? I'm ready for the questions.
All right. What if our rental house needs work and we can't do it with the renter there due to the work that needs to be done? Do we wait it out until after COVID?
Okay, so when you said rental work that has to be done, if it's pursuant to a government ordinance, meaning you've got an order to comply to do that work, the first thing you want to do is just contact the county or the city and talk to the inspectors. And inspectors, if they see you being proactive in trying to make the repairs, they're going to give you the leeway, they're going to extend. If the tenant's not letting you in to make those repairs, depending on what type of repairs you have, you may have that argument that public safety and health are at issue, such that you may be able to proceed with an eviction against them. If it's just, the tenant's comfort level and the landlord's comfort level, I think that a landlord's going to be excused if they don't have the money to make the repairs right now. Again, it depends, because if it's issues like, hot water, weatherproofing, heat, I think a landlord's going to have that obligation to make those repairs, and just has to work with the tenant to do so. But a lot of tenants don't want people coming in because of the pandemic. So I really think it's working with the tenant to something that makes sense. But I can tell you, if you're being ordered to make those repairs, talk to your inspectors, see what they want you to do. And if you really need to make those repairs and the tenant's being a pain, you may want to try to go get that eviction order, and that probably will get the tenant to let you in.
Great, thank you. Many commercial leases have damages language discussing at the time of the award. What is the significance of this language?
So at the time of the award, goes back to 1951.2, is at the time of the judgment being rendered. And so what that language means, as I was talking about, is there are future rent paragraphs in 1951.2 that says you get to accelerate the rent through the term of the lease that would be due, and that's due at the time of the award. And what they mean by that language is you discount that amount that's due in the future to present value to make it due now. So it's legalese that basically says it is it's accelerating the future rent obligations to be due at the time of judgment. Again, discounted to present value, and it's a formula that's in the statute, and it deals with the Federal Reserve rate in San Francisco, and it's discounted, and I can tell you more about it, but that's what it means.
Thank you. Most people will have personal guarantees. Would any of the defenses you suggested apply in the case of an expansive personal guarantee?
Yes, you're going to certainly employ all those those defenses in a personal guarantee. Again, I just want to be clear. I don't have an answer. I can't predict how those defenses will. It'll be case by case situation. But rest assured, when you are having to defend your breach of personal guarantee case against the landlord, you're going to employ commercial frustration, impossibility, commercial frustration. You're going to employ all of those defenses in a lawsuit. So it will equally apply to your personal guarantee. So when you're having that conversation with the landlord, you're going to raise that, and you're going to raise the issue of bankruptcy. And just on a quick point, in the future, and again, this is, most landlords require tenants to sign personal guarantees. That's a big thing to try to negotiate. Some things you want to think about as you agree to pay 1 year's rent. you do a personal guarantee only to the amount of a tenant improvement allowance given to you by the landlord. These are things that real estate lawyers, you know, can assist you with. So it's just something that, you know, if you did it, and you know, this is about the future, if anything, or if you know, if you have an amendment coming up, you're going to want to renegotiate your personal guarantee.
Great, thank you. Rosanna, I'm so sorry to hear this. Rosanna, we're thinking about you. She says that she's been in her complex for 30 years and her lease expires in December 2020. She's really trying to stretch it, but not sure if the business is going to make it until then. They don't have a personal guarantee. So what do you think the chances of the landlord, you know, if they don't make it to the end of their lease term, what do you think the chances are that the landlord will try and sue?
You know, it's a good, is it to the end of 2020? Is that what?
December 2020.
Okay, so look, you have, I don't know the amount of the rent, but if you have, you know, 7 months left, 8 months left on a lease, no personal guarantee. If I was the landlord, I would take possession, and unless I knew you were going to open up a shop somewhere else and keep the business alive, I'm probably going to walk away. You know, you know, a landlord has to take the position to don't want to throw good money after bad, and that is in the situation that just was told to me. There's just not much upside. If it's $25,000, what, I'm going to wait 2 years to get $25,000? You know, I'm going to focus my efforts on against a defunct company. It just doesn't make any sense. I'm going to focus my efforts on finding that new tenant, or trying to find a way to get you to extend your lease and keep you there. One of the things you guys need to also realize is, you know, I counsel my tenant clients to do whatever you can to avoid being a defendant in an unlawful detainer action, because the deck is completely stacked against you in an unlawful detainer action. When you balance risk, and lawsuits are all risk, and litigation's risk. The risk to a landlord in an unlawful detainer is here. The only thing it is money. It's loss of money. A risk to a tenant is here. If they lose an unlawful detainer, you're going to be kicked out. You know, now we have an eviction moratorium now, but in normal times, you're going to be kicked out of your property within, and this is residential commercial, within 2 weeks of that judgment being issued. You're going to have a judgment on your record for 7 to 8 years. You're going to have to pay back the money that's owed. You're going to possibly be sued for the future term of the lease, and you're going to have a bunch of attorney's fees to be paid. So I don't like playing defense. I'd rather try to pay my rent or try to stay in compliance with the lease and then sue the landlord affirmatively for bad conduct on the part of the landlord. So just that's an aside. I don't like playing defense in these situations.
Thank you. If you were negotiating for a tenant, what would be a reasonable settlement with a landlord other than deferral? Have you been able to negotiate permanent discounts for tenants, or heard of landlords accepting that?
You know, before COVID, the idea, you know, the general idea, and depending what type of real estate market is out there, the general idea is that 1 year, like if you know, a duty to mitigate, you know, and this is all subject to expert opinion, but a 1 year payment of rent can be a good starting point or an ending point. I have, again, it just depends on the situation, but you know, if you have 10 years left on your lease, paying a year, that's not unheard of. Depends what kind of company it is. It's a big company, you know, maybe 2 years, buying your piece. 6, if you're a small mom and pop, 3 months, 6 months. The problem now, everyone, is not that, you know, landlords may not be inclined to negotiate. The big problem is landlords are just as scared as tenants. So to negotiate a timeline and say, I'm going to let you out and you're going to pay me a year's amount of rent, the landlord is thinking, well, I now have a year and I have a year of money in my pocket today, which is good. But what if I don't get a tenant in the space within a year? Now I'm taking the risk. I mean, you hope the landlord's willing to take a little bit of a risk, but I really don't know. I'm right now in a negotiation where I keep trying to offer a year. My client doesn't have a personal guarantee, but he has a brand, and the brand is important. So it's one thing to realize, guys, as well. If you walk away and then you start your business somewhere else, the same business, the landlord can sue you at that new business under a couple theories of liability, being successor liability if you just change the name or change the LLC and think that that's going to protect you. The landlord's going to come after you under successor liability, or what's called a fraudulent conveyance, that you have taken out assets of the company to avoid creditors. So that's not an option. So therefore, it's hard. But to answer the question, the hard part I'm having is to get terminations, is landlords agreeing to it, because if you leave, they don't know who they're going to get to replace you. And that's really difficult. So what is making more sense in my negotiations is really trying to work out rent abatement, rent deferral agreements that work. But I can tell you that I'm going to have a call today or tomorrow with that landlord and say, we're not staying. And so you can either take the money now or you can chase us. And so we'll see how it plays out.
Great follow-up question to that. You seem to be in favor of longer-term leases. We are at the point where our lease will expire. The landlord wants us to renew for at least 3 years, but we would prefer 1 year with an option to do more. Nobody knows when the pandemic will end. What do you think we should do?
Well, so, you know, options are all for the benefit of a tenant, just so you know. So landlords hate options, okay? If the market is skyrocketing, a tenant is going to exercise that option because they've negotiated a fixed rent price in that option period that's probably going to be lower than market. And if the market is tanked, then the tenant's going to say, I'm not going to exercise that option, and I'm going to renegotiate, if I want to stay, the rent moving forward, or I'm just going to leave. So landlords hate options. That's why options are tricky. That's why options have trigger dates. And if you're a tenant, you should never miss the date to exercise an option. You got to have that counted. If you're a landlord, okay, don't notify the tenant that their option period is coming up. You just don't want to do that. You want the tenant to miss the option, exercise the option, because then you get to renegotiate everything. The more options you can get, that's great. I agree. I mean, you know, you want to limit. Here's the hard part for everybody. So the only reason, you know, if you spend hundreds of thousands of dollars to build out a space to make it viable, well, you need the period of time to recoup that investment. So you want a longer term lease. If you do a short lease and then it expires, if the market is super hot, the landlord's going to either kick you out or triple your rent, or, you know, take away he's going to be in the better bargaining position. I like the idea of, in your situation, depending, a 3 to 5 year would make sense. If you can get a 1 year with 4 or 5, you know, or 5 1-year options, fantastic. That just gives you the more certainty you need. If you can negotiate that, fantastic. I'm not sure a landlord would do that, but hey, you know, 3 years, 5 years. Again, if you spent hundreds of thousands of dollars to build out a space, or millions of dollars, you're going to want a longer term lease because you want to have the security to recoup that investment.
Great, thank you. My lease was originally signed by my late husband, who passed away 2 years ago. I have been trying to continue running the business as best I can, never late on rent, etc. I still have 5 years on the lease. Now I'm having health issues which prevent me from running the business. Do I have the right to walk away from the lease, since it wasn't me who originally signed it?
Who's the party to the lease? If the party to the lease is just the husband and you've continued to operate it, that's a really interesting question. Arguably, has there been an assignment of the lease to you such that you now have, you're personally liable. Now, I would say that at the very least, I know your husband passed away, but to the extent there's community property that you may have inherited, received, there's a chance they could recover that against you. If I was the landlord, I would take the position that the lease was assigned to you because you continue to operate it, and you both have performed with the understanding that there's been an assignment. But if I'm you, I take the position that I didn't sign anything, and I've continued to operate, and you had the right once he died to terminate the lease. And I'd make a couple arguments. I'd say I've just been operating on a month-to-month lease over the last period of time because when he died, the lease terminated. Or you can't touch me because you don't have a contract with me. It would be, it'd be very interesting. I'd be happy to want to talk to you more about that, but
You like this one.
I like it. It's interesting. It's very interesting. It really depends on the communications that have taken place since you've been operating.
Yeah, and it probably matters too if the business signed the lease or if he is the sole proprietor.
Well, if the business did, yeah, they're not going. Then it's okay because she's not personally liable anyway. So
Yeah. I let a prior tenant out of her lease due to COVID. If I get a new tenant in a new lease, it sounds like they are not required to pay rent.
That's a great question. Wow, that's a great question. You enter into a new lease, and you're right. On day one, they could invoke COVID to not pay you rent. So you better get a commercial setting. You can set any terms as you want. If you are worried about that, then make them pay 3, 4, 5 months, 6 months in advance of rent. That's a real concern. That's something that would be, I don't know the answer to this question off the top of my head, but in a commercial setting, much more than residential, in residential, you can, if a landlord and tenant come to an agreement on something, if it violates public policy, they're void. They don't have any effect. So you cannot waive the warranty of habitability in a residential lease aspect. Commercial is different. In commercial leases, the parties are both looked at to be sophisticated parties. And this will work against you guys, by the way, when you tenants who say this is unfair. The law looks at you as a sophisticated party that understood what they were signing and had the ability to have a lawyer represent them. So it would be interesting if a new contract, a lease entered into during COVID, whether if I was the landlord, I would write into the lease that the tenant, because he's demonstrated with financials and everything that they have the ability to pay, that they cannot invoke, and they waive the right to invoke the provisions of any city or county or state ordinance to not pay rent. I mean, I would document that and tell my client, the landlord, that I'm not sure it's enforceable, but you're going to put this in there and he's going to sign it. So when he tries to, when we get to litigation, I'm going to be able to have a fraud cause of action against him, saying that the tenant represented he could pay the rent for at least the next year, no matter what, or whatever period of time.
Well, and that could be another good tool in your toolkit if you're a tenant trying to renegotiate your lease, is just asking that question to your landlord. Have you looked at this? If you replace me, are you sure you can enforce rent? It could be interesting.
Yeah, it could be very interesting. Put you in a situation that says, can you even get rent moving forward? And so even if you get somebody in, but again, I think a sophisticated landlord is going to take significant money up front.
Yep. I'm a landlord and my tenant is a restaurant. Their lease expires August 31. This tenant has not paid rent for at least 4 months. I'm holding a security deposit, which is much less than the rent he owes. When can I sue the tenant for the rent owed? In my lease, it reads that I have to return the security deposit 3 months after the tenant vacates the premises. When does my 3 months start if he has not paid the rent for the last 4 months?
So depending, these moratoriums have found that non-payment of rent is not a breach right now. And so you can only, your time period to return the security deposit comes into play only upon a breach or the turnover, the relinquishment of possession. So that time period has not started for you. So you have to comply. You should already, there's nothing that prevents, as far as I know, the landlord, I think the lease allows you to do it. You can apply that security deposit now to the rent and say, it should be unilateral. You have to look at your lease, but it should give you the unilateral right to do so. And so landlords, you should be doing that. You should be applying your security deposit to the rent. And then it becomes interesting is what happens when this emergency period's over, when you then send the tenant the notice that they need to replenish the security deposit. I'm looking forward to that fight. That's going to be a very interesting fight. With respect to the tenant, the landlord, you're in a very unique situation because, as you said, the lease is going to expire in August. By the way, I don't know if the restaurant's going to leave or not, but you can't get him out of the premises when the lease expires. They want to stay. They'll just be holding over. And if it's just a business with no personal guarantee, if I'm the tenant, I'm going to milk any money I can get for as long as I can. And then as soon as you have the right to get rid of me, I'm going to hand you over the keys and say, come and get me, and basically, say, have fun. And that's really an unfortunate situation for the landlord here, because I don't know when you're going to get that 4 months of rent back, if you ever will. And if they stay longer, or whatever period they haven't paid rent, because if they're closing the business, who are you going to go after? Now, you have to look at each ordinance specifically, but these ordinances only talk about moratoriums on evictions. They don't talk about moratoriums on failure to pay rent, breach of lease. And I've already done this. If I have a tenant that is not paid rent that were pre-COVID, I have a client right now. It's a luxury home, and there is $20,000 a month rent that's due, and they haven't paid rent since last August. And don't get me started on why my client waited so long to do what they had to do. But the fact of the matter is, I started the eviction prior to COVID happening, and then we got stalled. Well, I've sued him for breach of contract and said that rent's, regardless if I can evict you, you owe for breach of contract. And I'm now in the pipeline. I'm in the system. So my trial date's going to be sooner rather than later. And so I'll tell that tenant, I filed that breach of lease action against the tenant and said, you think it's going to be 2 years. Well, I'm going to get you in, I'm going to get to court in a year. So stay all you want. And if you want it, I'm going to hopefully get a judgment against you and be able to collect on it. I mean, you can threaten that, and hopefully that gets the tenant to leave. Filing a breach of lease lawsuit is not very expensive to do, and it can give you some leverage in moving forward.
Great, thank you. I received an idle loan, but if I use it for business rent, obviously she can also use it to pay herself. She owns a fitness business and has only been able to use the space 3 weeks out of the last 4 months. What should she do? Well, and will the court say that she has to use her idle loan to pay the rent?
No, absolutely not. I mean, okay, and you should talk to your accountant. People should talk to their accountant. But when I counsel clients, and it's kind of just common sense, but you should talk to your accountants. You just gave me an example of where the tenant is receiving no revenue, basically. She's been open 3 weeks or whatever the period is. Her sales or her revenues have gone down significantly. So say you have your EIDL loan, okay? You're paying your salaries, you're paying your workers, you're paying yourself so you can provide for your family, you're paying to keep the lights on, you're paying for, expenses, whatever, vendors. you're also, as an owner, you're projecting the next 6 to 8 months and what you're going to need when things get better. And you may have some capital outlay you need to be able to pay. Guess what? That EIDL loan can be used for that. So under that whole scenario, I believe you, tenant, can demonstrate your inability to pay rent during this period. So even though you have the ILD loan, you can still argue in good faith that you can't pay rent, which is the whole point of these eviction moratoriums. Take the benefit of, that's the one thing the government has said, I don't have to pay. I'm going to wait as long as possible. Sorry, landlords, that's just the way it is. And I have debts that I need to pay, and I'm forecasting because I need to be able to rev up and get going once the economy gets back. Give you examples. When this first happened back in March, a bunch of accountants came to me and my firm and said, hey, I was chugging along for April 15th. I was going to get paid all my bills or invoices, when I completed the tax, the individual's taxes, the business taxes, and now everything got extended to July 15th. So now people couldn't pay, the tenants or the clients have a 3-month extension to pay the bill. The accounting firm has some revenue coming in, but the accounting firm took the positions, we're not paying rent because we have to be able to forecast what's going to happen in July, August, September, October, November, December. So I think that in your situation, especially, I don't see, I'm not a judge and I can't predict the future, but I think you have a good faith argument. It's exactly the way these moratoriums were written. You can demonstrate that you can't pay rent regardless of the fact that you have the EIDL loan. I think that's good public policy.
Thank you. I had 2 months past due rent prior to the shutdown. How does this change any of the things that you're talking about?
Well, you look at the way that, you got to look at each specific ordinance, and it talks about the non-payment of rent due to COVID. So you have a situation there where I think right now you get the benefit of the moratorium. The landlord can't do anything about it anyway right now. That's the one thing. He can't do anything about the prior 2 months. What I believe is when all this stuff ends, the moratoriums, that those 2 months are not going to be protected under any timeline or deferral timeline to pay back that rent. Those 2 months will become due and payable immediately. And the landlord, I think, would have the right to serve you with a notice to pay rent or quit for those 2 months. And as long as he just does those 2 months, could potentially have an eviction action against you. It's another interesting case to see how it played out. But right now, if you can, try to get those 2 months off the books. But I dealt with a client up in San Luis Obispo, and I took the position, the same thing. It was a business that owed prior rent, and the landlord threatened, oh, I can get you out for that. And I said, no, you can't. And by the way, I think the way that ordinance is written is that I have till the end of December to pay back that rent. And you can either work with me now, or I'll wait till December 31st, and my client will write the check for the full amount. And in the meantime, your landlord gets nothing and has to pay their mortgage and their property taxes or whatever the case may be. So it's an interesting issue. It's interesting.
Thank you. In the nail salon industry, we cannot possibly reopen during the pandemic. What options do tenants have? Can the lease be terminated? Again, a nail salon is similar to a hair salon, a movie theater. I think those type of industries are going to have better arguments than others with respect to being able to walk away and defense a case
that either there was commercial frustration, impossibility, that's going to, I think you have the better argument. At the same time, again, what I said earlier, what's going to work against you is the fact that the government has put things in place to protect you, PPP loans, EIDL loans, to help you to try to navigate these waters. My recommendation is to talk to the landlord and see if the landlord, no one's going to open up a nail salon after you leave, most likely. So who's going to want to take the risk? So I think a landlord in that situation really needs to have the conversation about some sort of rental abatement during this period. I just think a landlord not to do that is foolish, and it's going to take on a headache for themselves. And I hate to take money out of the landlord's pocket. I represent landlords. That's what I do. That's 85% of my business. But I think in certain industries, they're going to have to, if they want them to survive, have to work with them, or defer the rent till for as far out as possible. But I can tell you right now, I don't have an answer that says you can get. I can't tell you that you can just walk away, because I can't predict how courts are going to interpret it at this point.
Thank you. I have a spa and salon and have all independent contractors that rent space from me. Are they responsible for any back rent that they have not paid?
It depends what your agreement says. Is your agreement that, are they renting a chair, meaning do you have subleases with them? And is it called rent, or is it a fee? Because if it's a fee, yeah, you have the right to sue them for breach of contract. If it's rent, then right now the independent contractors have the benefits of the moratoriums. But yes, they're all obligated. Nothing has been passed that relieves anybody from the obligation to pay rent. So yes, it will be due and owing. It'll be up to you how you want to work it out with these independent contractors. But it depends what your written agreement says.
Thank you. Can a landlord get an eviction for a non-monetary breach of lease?
No. It's funny. When you read the ordinances, it seems to imply that you might be able to do so, but you can't get a summons issued. That's what the Judicial Council rule doesn't. It does not make that distinction at all. The Judicial Council rule just says that a court may not issue a summons on a complaint for an unlawful detainer unless the court finds in its discretion that the action is necessary to protect public health and safety. The Judicial Council rule trumps all these moratoriums by the cities and counties. So it means you cannot get any summons issued to evict for any reason right now unless public safety applies. You could serve a notice and make sure you read, you want to consult with a lawyer, because some of these moratoriums have penalties for serving notices that are improper or not allowed based on the language of that ordinance. So you want to check the ordinance, make sure you're in the clear. But if it's for a non-monetary default, what you can do is serve. If the moratorium is clear that you can do it, you want to serve it, because you want to take the position that the failure to cure the default declares a forfeiture of the lease, which allows you to immediately move forward with your eviction as soon as the state lets now start eviction actions again. So, that is what I would do, is I would serve the notices that they have the time to perform, because when a notice to pay rent or quit, or a notice to perform, cover, or quit expires, the landlord can declare a forfeiture of the lease, meaning the lease is over. So even when this all happens, you may be able to argue that the lease is over and I'm just suing to evict them. Where this all gets very ugly and is these rules that keep declaring every day a court holiday. And if it's a court holiday, then the last day to perform can't fall on a court holiday. So I haven't analyzed that issue. I'd have to look at it closer. But as I'm sitting here thinking about it, my declaring that forfeiture may not be, the time may not expire until the pandemic ends, but you've already given the notice and you'll be ahead of the game.
Great, thank you. Landlord is going through a financial burden due to tenant not paying rent. The landlord needs to sell it. Can she sell it? Just put up the for sale sign.
Is this a house?
Patty.
If it's a bit, yeah, a landlord can sell a business at any time. Now, if you have a lease, whether you be residential or commercial, the landlord sells subject to that lease. And so you as a tenant, either in residential or commercial, get to stay as long as you have a lease in place. And then if it's residential and you have like a month-to-month lease, I still believe there's protections in place that allow you to stay for some period of time. I don't know what they are. I haven't looked at that issue lately, but I can tell you that if the landlord wants to sell, yes, the landlord wants to sell. And quite frankly, that gives you leverage as a tenant. If the landlord's trying to sell, to say, you know what, you want to keep me in, you're only going to sell it for profit if I'm here as a tenant. So work with me, help me. Let's make a deal that makes sense for you, that at least in a year maybe the rent goes back to market rent or whatever the rent is. So you can then have be able to project profits for a future buyer that makes sense for them. But in the meantime, give me a little break.
Great, thank you. And follow up to that, does she need to serve notice to the tenants that she's selling?
I don't know residential. If somebody else has the answer to that question, I'd love to hear. In a commercial lease, it depends what your lease says. I don't believe they have to give anybody notice generally, but usually tenants find out, because if there's a loan on the property, or if the new buyer is going to take a loan, it's going to require the tenant to sign what's called an estoppel certificate that says, the landlord's in full compliance with the lease, the tenant is too, and there's no breaches, which is interesting with COVID. And then that the lease says what it says, because that's a net representation to the lender that the tenant's paying the rent he's supposed to be paying, and the term is the term. And then there's also subordination agreements where people potentially subordinate their rights to the lender. So a tenant will find out that a sale is happening because they're usually required to sign documents.
Great, thank you. We have 3 questions left and 2 minutes, it just clicked over. So we're gonna keep your answers snippy snappy. I've seen some discussions about illegal taking. Have you heard anything about that? So landlord organizations suing the governor.
Well, they can sue the governor. Well, yes, that's, this idea that in the legislature that they were going to modify leases and tell people that, redefine how much a landlord could recover in rent. That to me smells of an illegal taking. And so that's the proposed legislation that went forward. Whether I suspect there will be a class action against the governor that this moratorium constitutes an illegal taking. I don't know how it's going to play out, because again, all these moratoriums have said none of them relieve anybody from the obligation to pay rent. But in practically speaking, if tenants' leases expire or they walk away, then for all intents and purposes, and the landlord didn't have a remedy, it could constitute an illegal taking. By the way, like in the city of LA, there is talk, at least in the residential world, to forgive rents. And that to me is that's a taking. So we'll see how that plays out as time goes on.
Great. I couldn't pay 3 months of rent while we were closed, and I haven't sent the letter to my landlord. Should I send it now, even though it's late?
Yes, you should absolutely send it late and say, I was closed, so you knew that, and I assumed you knew, but I just want to make sure This is why I haven't been able to pay rent. I'm not able to operate. And I would give a little detail. And, you know, you want to, it's a good way of starting a dialogue with your landlord to see if you can, how you're going to move forward. Because here's the thing, guys, everybody, unless they give us uniformity on this timeline to pay back rent, you have a bad relationship with your landlord. Landlords can take the position that it's all due in 30 days or 3 days or 10 days when the pandemic ends. If you are talking to your landlord, and of course it takes two to tango, if you're talking to your landlord, regardless of what an ordinance says, like Ventura giving you 6 months and Santa Barbara maybe potentially a year, coming to some sort of an agreement with the landlord that gives you the time to pay back this back rent is just going to help you in the future. It's going to give you guys more certainty, peace of mind. It's not going to solve all your problems or make you feel that everything's going to be better, because nobody can predict the future, but it would be nice. I mean, I have a client who has a bar, a theater in Hollywood, and she can't pay anything. She's closed down, but the landlord's offering an incredible, not incredible, but he's a very decent offer that she can't afford to pay now, but she may want to take up and defer the rest, because the alternative is it'll all be due. It'll all be due when the pandemic ends. So it's, you know, you just got to figure out something that makes sense for everybody.
Great, thank you. Do you think the governor will extend the evictions again after September 30th?
As we're sitting here, yes. Today, yes. I don't, you know, we're seeing the spikeage of the COVID. I don't, you know, I'm just giving you my thoughts. I think it gets extended in September. I think this, you know, to the extent the state of California can help tenants, they're going to protect you. They don't want to have a rush of evictions. Very frustrating for landlords, but I think they will. And as I told you again, the sunset rule of the Judicial Council is 90 days after the governor declares the state of emergency to be lifted. So that means I think that even after September 30th, he lifts the order, at least the way I read it, unless they change it. I believe you're going to have 90 days still before somebody can get into court. And maybe that 90 days is where you work things out. One thing I want to make sure I mention is, because we talked about this yesterday with Emily and Claire and Brienne, that the CARES Act is set to expire. That's a federal eviction moratorium. Don't worry about it, because evictions are state actions, and these state laws trump all that anyway. Use the word Trump, but anyway, it allows you to, all the protections in place on the state, local levels remain. So don't get freaked out if you see that in the news.
Great, thank you. Well, we did it. We got through all of our questions, and you got some kudos in the chat. So sounds like this was pretty valuable for a bunch of people. So thanks for your time.
Oh, it was my pleasure. Really enjoyed talking to everybody. It's just, like I said, it's kind of a little bit of a passion. This is where I learned about the law doing landlord-tenant stuff, and it's really fascinating. Right now, it's at the forefront of how we move forward.
Great.
Thank you again, David. I'm super grateful that you were able to share your expertise today. I know it's been a huge topic of interest for everyone, and certainly law school obviously has paid off. I'm glad I didn't actually go that direction. I'm glad we have attorneys who know what they're doing, like you. So thank you again. Thank you everyone who participated and stayed as long as you did. We will send this recording out with a write-up of how you can reach David, and also just key points, key takeaways from today's webinar. So thank you all, and take care, and we'll see you next Wednesday. Bye-bye.